Limitation Act. Frequently asked questions on Limitation Act. Q. 1. Discuss briefly history of the law of limitation. Ans. History of law of limitation in India. There was no specific, uniform law of limitation till 1859. Under Hindu jurisprudence there was no law of limitation, since main source of earning of people was agriculture. So concentration was more on land and rights attached thereto, so there was law of prescription prescribing certain period of time for acquisition of title by prescription. Before 1859, law of limitation was being administered in two ways. Firstly, in territories within original jurisdiction of courts established by Royal Charter in the Presidency towns of Calcutta, Madras and Bombay, the English law of limitation, and in the Mofussil courts, the law as laid down by the regulations was administered. It is in 1859 first specific enactment on law of limitation was introduced which was applicable to all courts. The Act 14 of 1859 was then replaced by Limitation Act of 1871 which provided for limitation on suits, appeals and certain applications to courts. This Act also provided for acquisition of easements and extinguishment of rights on land and hereditary office at the determination of certain period. Act of 1871 was then replaced by Act of 1877. Limitation Act of 1877 was more comprehensive. It provided for law of prescription not only in respect of land or hereditary office but also to other movable properties. Later Act 1877 was also replaced by Act No. IX of 1908, which was more or less repeating the provisions of Act of 1877. The Act of 1908 remained in force till the present Act No. 36 of 1963 was passed. For many years the Government of the Republic of India has been much anxious to overhaul the provisions of the age-old Limitation Act, IX of 1908, which had been the subject of some controversial discussion at the bench and the bar. On the recommendation of the Law Commission, the old Act was repealed and the new Limitation Act came into force with effect from January 1, 1964. The Limitation Act, 1963 received the assent of the President on 5 October 1963 and was published in the Gazette of India on the same date. The present Act is a unique piece of legislation which contains several provisions of far-reaching nature. It gives statutory expression to the changes recommended by the Law Commission. It does not contain merely drafting changes but in many aspects it is a new enactment. Q. 2. What is significance of period of limitation? Ans. Unlimited and perpetual litigation disturbs the peace of society and leads to disorder and confusion. A constant dread of judicial process and a feeling of insecurity retard the growth and prosperity of a nation. The law of limitation prescribes this limit. The Romans, therefore, had the maxim interest republici ut sit fines litem. The interest of the state requires that a period should be put to litigation. The law of limitation prevents persons from enforcing their own rights, and disputing the rights of others, after a certain period of time, and thus quiets titles and enhances the value of property. The necessity for putting a limit to litigation arises also from the perishable nature of man and all that belongs to him. It has been said by John Woe that controversies are limited to a fixed period of time, lest they should be immortal while men are mortal. The Indian Limitation Act lays down definite rules of law, giving to the people for whose benefit they have been framed. A guarantee that after a lapse of certain period they may rest in peace and rely upon titles or other rights which they have acquired. Laws of limitation enjoins alertness upon the citizen by making a citizen who delays too long to lose his right altogether. Vigilantibus non domentibus jura subvenient, the laws assist the vigilant and not those who sleep over their rights, is well-known maxim providing one of the principles on which law of limitation is based. The law of limitation only bars the remedy of a person by means of a suit. It does not deprive him of his right if it can be exercised in any other manner than by means of a suit. Thus, where a suit or debt is barred by limitation, the debt nevertheless remains. It is open to the debtor to pay the barred debt and the payment cannot be recalled on the ground of failure of consideration. Similarly, a barred debt is a good consideration for a written promise to pay it. See Section 25 of the Contract Act. Section 27 of the Limitation Act creates an exception to the aforesaid principle. It provides that at the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. Q. 3. Laws of limitation are statute of repose and legally just and morally justified. Discuss. Hence the object of law of limitation is to prescribe periods after the expiry of which a suit cannot be maintained in court of law. The principle on which law of limitation is based is incorporated in well-known maxim, interest republic let sit finis licium, i.e. it is in the interest of the state that remedies for violated rights should be sought in courts of law without delay. Basically, the laws of limitation are founded on public policy. The statute of limitation is a statute of repose, peace and justice. It secures peace as it ensures security of rights and justice. Law of limitation primarily founded on public policy and serve the people to sit with peace of mind, after certain prescribed period. It puts limit to long-lasting litigation proceedings and thereby serve the people to enable them to prosper. Therefore, Mr. Justice Story has observed in Conflict of Laws, as law thus limiting suits are founded in the noblest policy. They are statutes of repose, to quiet titles, to suppress frauds and to supply deficiency of proofs arising from the ambiguity or obscurity or the antiquity of transactions. They proceed upon the presumption that claims are extinguished or ought to be held extinguished, whenever they are not litigated in the proper forum, court, within the prescribed period. They take away all solid grounds of the complaint because they rest on the negligence or neglect of the party himself. They quicken diligence by making it in some measure equivalent to right. They discourage litigation by bringing in one common receptacle all the accumulations of past times which are unexplained, and have now, from lapse of time, become inapplicable. Q. 4. Limitation bars the remedy but does not destroy the right. Discuss and state the exceptions if any. Uns. Section 3 of Indian Limitation lay down the general rule of Limitation Act and reads as under. Subject to the provisions contained in sections 4 to 24, inclusive, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed. Although limitation has not been set up as a defense, law of limitation is based on well-known maxim, interest republica ut sit finis litem, i.e. it is in the interest of the state that there should be an end to litigative process. The law of limitation is based on the principle that the law aids the diligent and not the indolent. That a man who has negligently slept over his rights for an undue length of time will not be allowed to litigate in respect of them. In Levy v. Rengi 3 Bohm 207. It was observed that the object of the Act is not to create or define causes of action but simply to prescribe the period within which existing rights can be enforced in court of law. The Limitation Act thus prescribes period within which various suits, appeals or applications for respective claims can be instituted in courts of law. If a party or claimant fails to do so, it cannot claim any further remedy at law. The rule of limitation is a rule of procedure. It does not either create or extinguish a right. In the words of Sir Richard Couch in Harinath v. Mather, 20 IA 188. The intention of the law of limitation is not to give right where there is none nor to extinguish a right where there is one but to interpose a bar after a certain period to a suit to enforce an existing right. Limitation thus simply bars the judicial remedy, without extinguishing the right. For example, where the recovery of a debt has become time-barred by the lapse of prescribed time. The right to the debt is not extinguished, and if the debtor, without being aware of the money due to him on the ground that his claim for recovery of the debt had become time-barred. In Punjab National Bank and other versus Surendra Prasad Simha, Air 1992 South Carolina 1815, Section 3 of Limitation Act bars the remedy but does not destroy the right to which the remedy relates to. Right to debt continues to exist notwithstanding remedy is barred. Right can be exercised in any other manner than by means of suit. It is settled law that the creditor would be entitled to adjust, from payment of sum by debtor towards time-barred debt. It is also equally settled law that creditor, when he is in possession of adequate security debt due, could be adjusted from security in his possession. Law of limitation is an absolute law and the parties cannot evade it by way of private agreement. Thus, under Section 28 of the Contract Act, an agreement which limits the time within which any party thereto may enforce his rights by the usual legal proceedings in ordinary tribunals is void. Similarly, an agreement between the parties that defendant will not plead the law of limitation in a suit brought against him by the other is void. However, there is one exception to rule that law of limitation bars the remedy but not the right. This has been incorporated in Section 27 of the Act. The section provides, at the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. In First National Bank Limited, Version Seth Sentlal. Air 1954 Punjab 328. It was observed. Section 27 of the Limitation Act is, however, an exception to the general rule that in personal actions, the Limitation Act bars only the remedy and does not extinguish the right. In a suit for possession of any property on the determination of the period of limitation, not only the remedy but the right also is extinguished under Section 27. But a debt does not cease to be due, because it cannot be recovered after the expiration of the period of limitation provided for instituting a suit for its recovery. After a debt becomes barred, a person is still deemed to owe. Q. 5. What is the difference between I. the doctrine of limitation and prescription, E. the doctrine of limitation and laches, E. the doctrine of limitation and acquiescence? Ans. I. Difference between limitation and prescription. The Indian Limitation Act deals with the law of prescription as well the law of limitation. A law of prescription prescribes the period at the expiry of which not only the judicial remedy is barred but a substantive right is acquired or extinguished. A law of limitation limits the time after which a suit or other proceeding cannot be maintained in a court of justice. It simply bars the judicial remedy, but it neither affects the extrajudicial remedies nor the substantive right itself. Prescription is the acquisition of title by possession of property for the prescribed period, provided that possession was neither forcible nor clandestine, hidden, nor permissive. Such possession acquires its title chiefly on account of the fact that those who had interest in the property have allowed their rights to get barred by not caring to pursue their remedies within pay time allowed by law to enforce those remedies. The following are some of the main differences of the law of limitation. 1. The law of limitation is a part of adjective law, being barring the remedy after expiry of the period of limitation, while the law of prescription is a part of the substantive law and it affects the substantive right of a person. 2. The Limitation Act prescribes the period after the expiry of which a suit cannot be filed in the court, while a right through prescription arises after the expiry of definite period of time. 3. The law of limitation imposes restrictions only on the judicial remedies and not on extrajudicial remedies, while a right extinguished due to prescriptions cannot be enforced by any judicial or extrajudicial method. E. Limitation and laches. The differences between limitation and laches are as under. 1. In case of limitation, the knowledge of the ignorance of the plaintiff, with reference to his right, is deemed immaterial, while the knowledge of the plaintiff about right, if proved, defeats the claim due to laches. The term laches here means negligence or slackness. The doctrine of laches is based on the principle that backward delay defeats equity. In Roopchand vs. Madan Mohan Air 1960 Cull. 351, it was observed that the basis of doctrine of limitation is public policy, while basis of the doctrine of laches is backward equity. Laches, like limitation, no doubt deprive plaintiff of his remedy, but it depends upon general principles of justice and fair play, while limitation depends upon express law. A positive rule of limitation cannot be depended whether there is laches or not, and except in the case of discretionary order. The defense of laches or acquiescence cannot prevail when a statutory period of limitation is prescribed for action. 2. Limitation prescribes a period of time within which a suit must be filed in the court, whereas period time is not fixed for laches. In case of laches, it is the duty of a court to see a. whether the evidences of the case have been lost or destroyed due to the delay caused by plaintiff, b. whether the plaintiff caused unreasonable delay, and c. whether the defendant has been induced by the plaintiff by causing delay or commission to alter his position or to incur an expense. The doctrine of laches is applied in India in the following cases. I. Cases relating to the Specific Relief Act. E. Cases of temporary injunction. E. Cases of interlocutory orders. IV. Cases relating to marriage and divorce. V. Cases relating to limitation. 3. The law of limitation is based on public policy in general utility, while laches is based on equity. 4. The law of limitation is based on expression, while laches is based on the doctrine of impartial judicial behavior. 5. The plea of limitation is raised by the defendant against the plaintiff, while the plea of laches can be raised against both, i.e. plaintiff or defendant. E. Limitation and acquiescence. Acquiescence implies an active consent of a party. It widely differs from limitation, particularly on the following points. 1. Limitation indicates towards the provision against which a suit cannot be filed in a court after the expiry of the prescribed time, while acquiescence refers to a position in which an objection is not raised by person against an act done by another person having a right to do so, provided that it is not inconsistent with the right of the former. 2. The right of a person to file a suit or initiate the proceeding is extinguished after the expiry of period of time, while acquiescence is most wide in comparison to that because a consent is involved in it. 3. The acquiescence can either be direct or indirect, but it is not so in case of limitation. 4. The acquiescence is based on knowledge and conduct of the concerning party, while it is not so in case of limitation. 5. When acquiescence is proved, a person who did so loses his right to file a suit in the court, irrespective of the fact that the time for filing a suit has since expired or not. Q. 6. Every suit instituted, appeal preferred, and application made after the period of limitation prescribed therefor shall be dismissed. Explain the statement with reference to its exceptions, if any. Uns. Section 3(1) of the Limitation Act provides as under, subject to the provisions contained in sections 4 to 24, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. So Section 3 of Limitation Act gives the general rule of limitation by providing that a suit or an appeal or an application filed beyond the time prescribed therefor shall be dismissed, although limitation is not set up as defense by opposite party. In Ashok K. Khurana vs. M. S. Steelman Industries and others, Air 2000 Delhi 336, it was observed. Mere reading of Section 3 of the Act shows that it is mandatory and absolute in nature. It enjoins upon the court to dismiss any suit instituted, appeal preferred or application made after the prescribed period of limitation, although limitation has not been set up as a defense. Courts have no discretion or inherent powers to condone the delay if the suit is filed beyond the prescribed period of limitation. Rather, a duty is cast on the court to dismiss the suit. Appeal or application if the same is barred by limitation unless matter is covered by sections 4 to 24 of the Act. So it becomes clear that provisions of Section 3 of the Act are mandatory in nature. Section 3 enjoins a court to dismiss every suit, appeal or application which is not within the prescribed period. Gateways from the peremptory provisions of Section 3 are provided by Sections 4 to 24. In other words, the court has no power, apart from the provisions of Sections 4 to 24, to relieve a litigant from the bar of limitation even on equitable consideration or on grounds of hardship or in exercise of its inherent powers. Section 4 of the Act provides that where the prescribed period for any suit, appeal or application expires on a day when the court is closed, the suit, appeal or application may be instituted, preferred or made on the day when the court reopens. Then Section 5 of the Act provides that an appeal or any application other than the application under any of the provisions of Order 21 of the Code of Civil Procedure may be admitted after the prescribed period, if the appellant or applicant satisfied the court that he had sufficient cause for not preferring an appeal or making the application within such period. Sections 6 to 8 of the Act extend the period of limitation in cases where the limitation expires before the cessation of disability, i.e. minority, insanity or idiocy. Sections 12 to 15 of the Act provide for excluding certain periods in computing the period of limitation. Then Sections 16 to 24 of the Act provide for the effect of death, fraud, mistake, acknowledgement in writing, part payment, addition or substitution of new plaintiffs or defendants, and continuous wrong. In such cases, the Act provides the date from which the fresh period of limitation shall begin to run. Q. 7. A suit is held in a court and decree is passed in favor of the plaintiff. No objection on the point of limitation has been raised by defendant or anyone else. Can the plea of limitation be based for the first time? I. In the first appeal. E. In the second appeal? If so, under what conditions and by whom? Ans. Section 3(1) of Indian Limitation Act lays down, subject to provisions contained in Sections 4 to 24, inclusive, every suit instituted, appeal preferred and application made after the prescribed period shall be dismissed although limitation has not been set up as a defense. So from here provision it is evident that any suit, appeal or application filed after prescribed period shall be dismissed although limitation has not been taken up as defense by other party provided case of plaintiff comes in any of exceptions as contemplated in Sections 4 to 24. But general rule is suit, appeal or application after the expiry of prescribed period is barred by limitation. Word, shall, used in Section 3 makes it clear that even if point of limitation may not be raised by other party, court is duty bound to see whether the suit, appeal or application is within limitation or not, and if it is not and neither comes in any exceptions is incorporated in sections 4 to 24, then court has no option but to dismiss it. So court is bound to take notice of point of limitation if it appears from facts enshrined in plaint, or in other words court cannot escape from taking note of defect of limitation. When it is purely a question of law capable of determination on the facts on the face of plaint. But situation is different when it is a complicated and mixed question of law as well of facts, which in some situations is incapable of being determined in present facts and circumstances. Plea of limitation in courts of first or second appeal in Hanuta Ram vs. Sikh, Ram. Air 1971 South Carolina 2831. It was observed that a question of limitation can be raised in appeal though the same was not raised in trial court. Reference may be made of K.V. Rao vs. D.V. Rao, 1956 Andhra H.R. 1956. Similarly in Kashi Ram vs. Kundan Lal, Air 1955 All. 660. It was held that where the claim is time-barred on allegations contained in plaint itself, there is no reason why the plea of limitation should not be upheld if raised in appellate court. In Banarsi Das vs. Kanshi Ram, AIR 1963 SC 1165. It has been held that a new plea of limitation which is not one purely of law but is a mixed question of fact and law should not be allowed to be raised for the first time in second appeal, more so by defendants who have not filed a written statement in the case. Even if the High Court feels inclined, in view of Section 3 of the Limitation Act, to allow the plea to be raised in such a case, it should at least give an opportunity to the parties which supported the decree of the trial court to meet the plea of limitation by amending their pleadings, and after the pleadings are amended, the High Court should frame an issue and remit it for a finding to the trial court. When it cannot be raised, the plea of limitation for the first time in the appellate court can be taken only when the fact necessary to determine the question of limitation are admitted or are apparent on the face to pleading. Thus, where the suit is not on face of it obviously barred by limitation, the appellate court should not take up the question of limitation on its own initiative. The appellate or second appellate court is justified in refusing to entertain a plea of limitation which was not taken in the first court in the ground of appeal in the appellate court but is urged for the first time in the latter court where the plea for its proper decision involves further inquiry into facts. Q. 8. What will be the effect when prescribed period for any suit or appeal or application expires on the day when court is closed? Ans. Section 4 of Indian Limitation Act provides, where the prescribed period for any suit, appeal or application expires on a day when the court is closed, the suit, appeal or application may be instituted, preferred or made on the day when the court reopens. Explanation added to Section 4 of the Act says, a court shall be deemed to be closed on any day within the meaning of this section if during any part of its normal hours it remains closed on that day. Section of the Act is based on well-known maxims, lax non cogit ad impossibile, i.e. law does not compel a man to do impossible act. Actus curia nemanem gravabit, an act of the court shall prejudice no man. Section 4 of the Act does not extend the period of limitation. It merely embodies a rule of elementary justice that if the time allowed by statute to do an act or to take a proceeding expires on a day when the court is closed, it may be done on the next sitting of the court. Their Lordships of the Privy Council observed in Maqbool Ahmad vs Onkar Pratap, AIR 1935 PC 85 that what the section provides is that where the period prescribed expires on a day when the court is closed, notwithstanding that fact, the application may be made on the day that the court reopens, so that there is nothing in the section which alters the length of the prescribed period. Q. 9. Under what circumstances can delay be condoned in the filing of appeal and applications? Uns. It has been laid down in Section 5 of the Limitation Act that any appeal or any application other than application under any of the provisions of Order 21 of the Code of Civil Procedure, 1908, may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. Explanation says, if the appellant or the applicant was misled by the order, practice or judgment of the High Court in ascertaining or computing the prescribed period, it may be a sufficient cause within the meaning of this section for extension of period of limitation. The provisions of Section 5 of the Act are an exception to the general rule laid down in Section 3 that every suit instituted, appeal preferred and application made after the prescribed period shall be dismissed. It will seem from the above that the provisions contained in Section 5 applies only to appeal and certain applications mentioned therein and not on the suits. The reason is that period prescribed for applications and appeals mentioned in this section does not exceed 6 months while for suit it extends from 3 to 12 years. Therefore, this conclusion has been given in this section for applications and appeals in certain circumstances. It is necessary to get the benefit of this section that the court must be satisfied with the sufficient causes for not preferring the appeal or application. The term "sufficient cause" used here has not been defined in this Act. Its meaning, therefore, can be accepted as a cause which is beyond the control of the party invoking the aid of this section. This term "sufficient cause" must of course be given a liberal meaning so as to advance substantial justice when any negligence or inaction or want of bona fide is not imputable to the appellant. The sufficient cause can be determined from the facts and circumstances of a particular case. The power given to the courts under Section 5 above is discretionary, yet it has to be exercised in a judicial manner keeping in view the special circumstances of each case. In Collector, Land Acquisition vs. MST. Patiji, Air 1987 SC 1353, their Lordships of the Supreme Court laid down the following guiding principles. 1. Ordinarily a litigant does not stand to benefit by lodging on appeal late. 2. Refusing to condone delay can result in a meritorious matter being thrown out at the very threshold and cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that a cause would be decided on merits after hearing the parties. 3. Every day's delay must be explained, does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common-sense, pragmatic manner. 4. When substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred, for the other side cannot claim to have vested right in injustice being done of a non-deliberate delay. 5. There is no presumption that delay is occasioned deliberately, or on account of culpable negligence, or on account of mala fides. A litigant does not stand to benefit by resorting to delay. 6. It must be grasped that judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and it is expected to do so. It was pointed out that the courts should adopt liberal approach in the matter of condonation of delay, keeping in view the above principles. Q. 10. Explain the doctrine of sufficient cause. Ans. Section 5 of Indian Limitation Act provides, any appeal or any application other than an application under any of the provisions of Order 21 of Code of Civil Procedure 1908 may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. So any appeal or application, other than one made under Order 21 of CPC, may be admitted after prescribed period if appellant or applicant, as the case may be, shows sufficient cause for not preferring appeal or making application within the prescribed period. But mere proof of existence of sufficient cause for not filing the proceeding within the prescribed period does not, under the section, ipso facto compel the court to extend the time. The court has a discretion to admit or refuse the proceeding even if sufficient cause is shown. In Sandhya Rani v. Sudha Rani Air 1978 South Carolina 537, Supreme Court observed, it is undoubtedly true that in dealing with the question of condoning the delay under Section 5, the party seeking relief has to satisfy the court that he had sufficient cause for not preferring the appeal or making the application within the prescribed time, and this has always been understood to mean that the explanation has to cover the whole period of delay. However, it is not possible to lay down precisely as to what facts or matters would constitute "sufficient cause" under Section 5. But those words should be liberally construed so as to advance substantial justice when no negligence or any inaction or want of bona fides is imputable to a party, i.e., the delay in filing an application should not have been for reasons which indicate the party's negligence in not taking necessary steps which he would have or should have taken. What would be such necessary steps will again depend upon the circumstances of a particular case. Discretion is conferred on the court before which an application for condoning delay is made, and if the court, after keeping in view relevant principles, exercises its discretion granting relief unless it is shown to be manifestly unjust or perverse, the Supreme Court would be loath to interfere with it. Explanation to Section 5 says that, the fact that the appellant or the applicant was misled by any order, practice or judgment of the High Court in ascertaining or computing the prescribed period may be sufficient cause, within the meaning of this section. The following are some examples of what is and what is not sufficient cause. 1. Illness. Illness is considered as "sufficient cause" to get benefit of Section 5. But mere plea of illness is not sufficient cause for not filing proceeding in time unless it is shown that the appellant or applicant was utterly disabled to attend to any duty. 2. Imprisonment. A person can be given the benefit of Section 5 if he is undergoing imprisonment due to some criminal act. The time spent by him in the jail may be deducted from the prescribed period of time. 3. Mistaken legal advice. A mistaken advice given by a legal practitioner may in circumstances of particular case give rise to "sufficient cause", within the meaning Section 5. In State of WB versus the Administrator. Howrah Municipality, Air 1972 South Carolina 749, it was held that if a party had acted in a particular manner on a wrong advice given by his legal advisor, he cannot be held guilty for negligence so as to disentitle the party to plead sufficient cause under Section 5 provided that no negligence, nor inaction nor want of bona fides is imputable to a party. 4. Illiteracy. The fact that appellant was illiterate is not sufficient reason to condone the delay. 5. Delay in obtaining copies. When a delay is caused, a. Obtaining a copy of the order or decree of a court and such delay was caused by the officer of the court. B. By the court itself in issuing orders. C. Due to the method wrongly adopted in procuring the copy of the decree or order of the court. Such delay shall be deemed as sufficient cause for granting benefit of Section 5 of this Act. In Collector of Land Acquisition vs. MST. Pettigee Air 1987 South Carolina 1353, Supreme Court laid down following principles for dealing the application under Section 5. I. Ordinarily a litigant does not stand to benefit by lodging an appeal late. E. Refusing to condone delay can result in a meritorious matter being thrown out at the very threshold and cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that a cause would be decided on merits after hearing the parties. E. Every day's delay must be explained, does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common-sense, pragmatic manner. IV. When substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred, for the other side cannot claim to have vested right in injustice being done of a non-deliberate delay. V. There is no presumption that delay is occasioned deliberately, or on account of culpable negligence, or on account of mala fides. A litigant does not stand to benefit by resorting to delay. V. It must be grasped that judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and it is expected to do so. It was pointed out that the courts should adopt liberal approach in the matter of condonation of delay, keeping in view the above principles. Q. 11. While going to the court for filing a suit, Ramesh meets with an accident. As a consequence thereof, Ramesh remains unconscious for 15 days. The period of limitation for filing the suit expires during this period. Can Ramesh claim extension of time? Ans. Section 3(1) of Indian Limitation Act 1963 provides the general rule that, subject to the provisions contained in sections 4 to 24, every suit instituted, appeal preferred and application made after the prescribed period shall be dismissed, although limitation has not been set up as defense. So no one can take concession from the above said rule except only when his case comes within any of the exceptional circumstances enumerated in sections 4 to 24 of Act. Apart from these exceptions, court cannot grant an exemption from limitation on equitable consideration. Section 5 though provide for condonation of delay for "sufficient ground", Section 5 lays down, any appeal or application other than an application under any of the provisions of Order 21 of the Code of Civil Procedure 1908, may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. But Section 5 of the Act has no application for filing suits, and there is no provision in sections 4 to 24 which either condones or extends the period of limitation for filing suit if plaintiff becomes unable to file suit within prescribed period due to accident. In view of the above discussion, limitation for the suit of Ramesh cannot be extended for sufficient cause because Section 5 has no application to suits. Q. 12 Y. The appellant handed over some papers to his advocate K. in the morning of the last day for filing the appeal. Through pressure of urgent work, the advocate did not look into the papers till the evening of that day, when he found that that was the last day. The appeal was filed on next day. Is there sufficient cause to grant the appellant an extension of a day under Section 5 of Limitation Act? Decide with the help of case law. Ans. Section 5 of the Limitation Act 1963 reads as, any appeal or any application, other than an application under any of the provisions of Order 21 of the Code of Civil Procedure, 1908, 5 of 1908, may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. On sufficient cause being shown, an appeal can be admitted by court even after the period of limitation has expired. It is difficult to define precisely the meaning of the words, sufficient cause, or "sufficient reason". To do so would be to crystallize into a rigid definition that judicial power and discretion which the legislature has, for good reasons, left undetermined and unfettered. In Sandhya Rani vs. Sudha Rani Air 1978 South Carolina 537, Supreme Court observed, "It is undoubtedly true that in dealing with the question of condoning the delay under Section 5, the party seeking relief has to satisfy the court that he had sufficient cause for not preferring the appeal or making the application within the prescribed time, and this has always been understood to mean that the explanation has to cover the whole period of delay. However, it is not possible to lay down precisely as to what facts or matters would constitute "sufficient cause" under Section 5. But those words should be liberally construed so as to advance substantial justice when no negligence or any inaction or want of bona fides is imputable to a party, i.e., the delay in filing an application should not have been for reasons which indicate the party's negligence in not taking necessary steps which he would have or should have taken. What would be such necessary steps will again depend upon the circumstances of a particular case. Discretion is conferred on the court before which an application for condoning delay is made, and if the court, after keeping in view relevant principles, exercises its discretion granting relief unless it is shown to be manifestly unjust or perverse, the Supreme Court would be loath to interfere with it. In G. Ramegoda v. Special Land Acquisition Collector, Air 1988 South Carolina 897, it was held that there is, it is true, no general principle saving the party from all mistakes of its counsel. If there is negligence, deliberate or gross inaction or lack of bona fides on the part of the party or its counsel, there is no reason why the opposite side should be exposed to a time-barred appeal. Each case will have to be considered on the particularities of its own special facts. However, the expression "sufficient cause" in Section 5 must receive a liberal construction so as to advance substantial justice, and generally delays in preferring appeals are required to be condoned in the interest of justice where no gross negligence or deliberate inaction or lack of bona fides is imputable to the party seeking condonation of the delay. In the present case, the counsel has pleaded his inadvertence and pressure of work. There is no deliberate or gross inaction or lack of bona fides on the part of the counsel. The appellant had handed over the papers to his counsel, although that was the last day of limitation. There is a delay of 1 day, and sufficient cause has been shown for the same. Therefore, the court should condone the delay in the present case. Q. 13. What is legal disability? To what extent such disability extends the period of limitation under the Indian Limitation Act? Ans. Generally, limitation begins to run from the date of cause of action. But the Indian Limitation Act itself provides certain exceptions to this general principle. Thus, in a case where the aggrieved party is suffering with some legal disability, the period of limitation does not run from the date of the accrual of the cause of action but runs from a subsequent date, on which the disability ceases. In this connection, Sections 6, 7 and 8 of Indian Limitation Act are the counterpart of each other and they unitedly form one unit. The general rule regarding disability is provided by Section 6, which reads as under: 1. Where a person entitled to institute a suit or make an application for the execution of decree is at the time from which the prescribed period is to be reckoned, a minor or insane, or an idiot. He may institute the suit or make the application within the same period after the disability has ceased, as would otherwise have been allowed from the time specified therefore in the third column of the schedule. 2. Where such person is, at the time from which the prescribed period is to be reckoned, affected by two such disabilities, or where, before his disability has ceased, he is affected by another disability. He may institute the suit or make application within the same period after both disabilities have ceased as would otherwise has been allowed from the time so specified. 3. Where the disability continues up to the death of that person, his legal representative may institute the suit or make the application within the same period after the death, as would otherwise have been allowed from the time so specified. 4. Where the legal representative referred to in subsection 3 is at the death of person to whom he represents, affected by any of such disability. The rules contained in subsections 1 and 2 shall apply. 5. Where a person under disability dies after the disability ceases but within the period allowed to him under this section, his legal representative may institute the suit or make the application within the same period after the death, as would otherwise have been available to that person had he not died. Explanation. For the purposes of this section, minor includes a child in the womb. So section 6 does not prevent running of limitation but only extends the period of limitation on the ground of disability of person entitled to sue or apply. Section 6 excuses an insane person, minor and an idiot to file a suit or make an application for the execution of a decree within the time prescribed by law and enables him to file the suit or make an application after the disability has ceased, counting the period of time from the date on which the disability ceased. If one disability supervenes on another disability or one disability is followed by another without leaving a gap, the suit or application for execution may be filed after both disabilities have ceased to exist. If the disability or disabilities continue till the person's death, then the legal representative of the deceased on whom the title devolves is allowed to file a suit or make an application for execution within the time allowed by law, counting it from the death of the person entitled. The mere fact that there is a guardian for the person under disability does not deprive such person of the indulgence granted by Section 6. In Akhtar Hussain vs. Qudrat Ali Air 1923 Odd. 31, it was observed that Section 6 of Limitation Act has no application in case of appeals. Legal disability is inability to sue owing to minority, lunacy or idiocy. The effect of legal disability is that it extends the period of limitation but it does not prevent the period from running. Sometimes a situation arises when one of the several persons jointly entitled to institute a suit or to execute a decree is under disability. In this connection, Section 7 of Act says that if one of the several persons jointly entitled to institute a suit or make an application for the execution of a decree is under any such disability and a discharge can be given without the concurrence of such person, the time will run against all of them. However, if such discharge cannot be given, Time will not run as against any of them until one of them becomes capable of giving such discharge without the concurrence of the other or until the disability has ceased. So Section 7 of Limitation Act would apply when the right to sue is joint irrespective of whether the substantive right is joint or not. Section 8 of Indian Limitation Act makes it clear that rules contained in Sections 6 and 7 are subject to the following conditions. 1. They cannot be applied to the suits to enforce rights of preemption. 2. They cannot be applied to any of the cases in which extension of period of limitation for more than 3 years from the cessation of disability or the death of a person as the case may be, is sought for. Q. 14. I, A, incurs a debt to a firm of which B, C, D, are partners. B is insane and C is minor. D can give discharge of the debt without concurrence of B and C. When will time run against B, C, and D? E. A right to sue accrues to Z during his minority. After the accrual but while Z is still a minor he becomes insane. When will the period begins to run? Uns. I. Section 7 of Indian Limitation Act is supplement to Section 6. Section 6 of Act excuses an insane person, minor and idiot to file a suit or make an application for the execution of a decree within the time prescribed by law and enables him to file suit or make an application after the above said disability has ceased, counting the period of time from the date on which disability ceased. Then Section 7 lays down where one of several persons jointly entitled to institute a suit or make an application for the execution of a decree is under any such disability and a discharge can be given without the concurrence of such person. Time will run against them all. But where no such discharge can be given, time will not run as against any of them until one of them becomes capable of giving such discharge without the concurrence of the others or until the disability has ceased. In the case in hand B, C, and D are partners. Every partner being an agent of every other partner for purposes of firm's business can give a valid discharge for debts of partnership. Here B and C are under disability and cannot give a valid discharge in respect of debt due to firm. But D can give a discharge without the concurrence of B and C, hence time would run against all of them. E. Section 6, 1, of Act says, where a person entitled to institute a suit or make an application for the execution of a decree is, at the time from which the prescribed period is to be reckoned, a minor or insane, or an idiot, he may institute the suit or make the application, within the same period after the disability has ceased, as would otherwise have been allowed from the time specified therefor in the third column of the schedule. Subsection 2 to Section 6 is relevant for the case in hand and reads as under. Where such person is, at the time from which the prescribed period is to be reckoned, affected by two such disabilities, or where, before his disability has ceased, he is affected by another disability, he may institute the suit or make the application within the same period after both disabilities have ceased. as would otherwise have been allowed from the time specified therefore in the third column of the schedule. Therefore, in view of section 6(1) and 2, time of limitation for Z will begin to run when his both the disabilities, i.e. minority and insanity, will cease. Q. 15. Does the law of limitation make any, if so what, allowances in favor of plaintiff on the ground that one of the persons jointly entitled with him was a minor? Ans. Section 17 incorporates provisions relating to legal capacity to give discharge without the concurrence of the person under disability. Discharge can be given according to the provisions of Section 7 provided the discharge can be given by one of the decree holders irrespective of the consent of the other decree holders. Where without the consent of the other decree holders no discharge can be given, the minority, insanity or idiocy of any of them will entitle all to an extension of time, and time will not start against any of them until the disability ceases. The provisions of Section 7 are merely an extension of the provisions of Section 6. The term "jointly entitled" in Section 7 clearly indicates that the provisions of this section is attracted only where several persons have same cause of action. This section does not apply where several persons possess several and distinct causes of action. Such cause of action cannot be allowed to be joined together. For example, where several persons are in the position of a tenant in common with regard to substantive right, and each of them can bring a suit separately, in relation to his own interest. There is not a joint right to sue, therefore provisions of Section 7 cannot be attracted. It is a judicially settled principle that where two or more persons are permitted to join together as plaintiffs by taking recourse to the provision of Order 1, Rule 1 of the Code of Civil Procedure, they cannot be said to be jointly entitled to institute a suit within the meaning of Section 7 of the Act. In short, it can be said that the provisions of Section 7 are attracted only where persons are having joint substantive rights. Q. 16. Where once time begun to run, no subsequent disability or inability to institute a suit or make an application stops it. Discuss. Refer to decided cases. Ans. It is a fundamental principle of law of limitation that, once the time has commenced to run, it will not cease to do so by reason of any subsequent event. In other words, the time runs continuously and without any break or interruption until the entire prescribed period has run out and no disability or inability to sue occurring subsequently can stop it. This rule has been embodied in Section 9 of the Act in the following words: where once time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it. Provided that, where letters of administration to the estate of a creditor have been granted to his debtor, the running of the period of a limitation for a suit to recover the debt shall be suspended while administration continues. This section applies not only to suits but to applications as well. This has not been expressly provided in the section. If at the date on which the cause of action arose the plaintiff was under no disability or inability, then time will naturally begin to run against him because there is no reason why the ordinary law should not have full operation. Section 9 says that once time has begun to run, no subsequent disability or inability to sue can stop its running. This applies to a person himself as well as to his representatives in interest after his death. The section contemplates a case of subsequent and not of initial disability, that is, it contemplates those cases where the disability occurred after the accrual of the cause of action. Whereas cases of initial disability have been provided for by Section 6. Disability or inability to sue. Disability has been defined as the want of legal qualification to act and inability of the physical person to act. Thus, according to Calcutta High Court in Puran Chandra vs. Sasson, Hair 1919 Cal. 1018, disability is the state of being minor, insane or idiot, whereas illness, poverty etc. are instances of inability. In Union of India vs. Tata Engineering and Locomotive Company, Limited, Air 1989 Pat. 272, it was observed, true it is that in terms of Section 9 when time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it, but Section 9 does not provide for a computation of period of limitation. Exceptions. The principle of Section 9 is strictly applied and no exceptions other than those which the Act itself prescribes can be recognized. Thus the running of time is suspended in following 8 cases. 1. The proviso to Section 9 contains exception to the general rule that once time begins to run, no subsequent disability or inability to sue can stop it. The proviso lays down that when the administration of an estate has been given to a debtor of the deceased, no time will run against such a debtor until the administration of a estate which has been entrusted to him has been finished. In such cases, the law prevents the duty of properly administering the estate to come into conflict with the right of the person to sue for the debt. The hand to give and the hand to receive is the same. 2. The time spent in obtaining a copy of the decree, sentence or order appealed from or sought to be reviewed shall be excluded while computing the period of limitation prescribed for an appeal or an application for leave to application and an application for review of judgment. In the same way, the time spent in obtaining the copy of the award shall be excluded, while computing the period of limitation to file an application to set aside an award. Section 12. 3. The time taken for prosecuting an application for leave is to be excluded if leave is necessary while computing the period of limitation for a suit or appeal. Section 13. 4. If the defendant is absent from India or in the territories beyond India, under the administration of the central government, the time up to which he has been absent shall be excluded while computing the period of limitation. Section 15. 5. 5. When the plaintiff has been prosecuting with due diligence another same proceedings, the time spent in it shall be excluded while computing the period of limitation. Section 14. 6. When an injunction or order has been obtained to stay the institution of suit, the time spent in obtaining injunction or order shall be excluded while computing the period of limitation. Section 15. 1. 7. When notice is served before the institution of a suit, The limitation shall be suspended during the period of notice, Section 15, 1. 8. The period of limitation shall be suspended during the time for which the proceedings to set aside the sale has been prosecuted in a suit for possession by purchaser at an execution sale, Section 15, 4. Q. 17. Discuss the present law of limitation in relation to suit for recovery of trust property. Can the legal representatives of an express trustee take the plea of limitation? Ans. Section 10 of Indian Limitation Act says, notwithstanding anything contained in the foregoing provisions of this Act, no suit against a person in whom property has become vested in trust for any specific purpose, or against his legal representatives or assigns, not being assigns for valuable consideration, for the purpose of following in his or their hands such property, or the proceeds thereof, or for an account of such property or proceeds, shall be barred by any length of time. Explanation. For the purposes of this section, any property comprised in a Hindu, Muslim or Buddhist religious or charitable endowment shall be deemed to be property vested in trust for a specific purpose, and the manager of the property shall be deemed to be the trustee thereof. This section altogether corresponds to Section 10 of the repealed Act 9 of 1908. The rule of this section follows the English law laid down under Section 25, 2, of the English Judicature Act, 1873. Scope. The beneficiary's remedy comes within the scope of this section, and it is well settled, both as regards real estate or personal estate. That time does not in equity bar the remedy of the beneficiary against the trustee. The section clearly lays down the rule that when a trust has been created expressly for some specific purpose or object, and property has become vested in a trustee upon such trust, the person who is beneficiary interested in that trust may bring a suit against such trustee to enforce that trust at any distance of time without being barred by the law of limitation. A fraudulent trustee who has misappropriated the trust property cannot escape from his liability under this section notwithstanding any length of time has expired. Section 10 applies to express trusts only and does not apply to implied, resulting or constructive trusts are enumerated in Chapter 4 of the Indian Trust Act, 1882. The following conditions must be fulfilled before the benefit of this section can be had. 1. There must be property which has become vested in a person in trust for a specific purpose. 2. The suit must be against such person or his legal representative or assign, not being assigned for valuable consideration. 3. The suit must be for the purpose of falling in the hands of such person the trust property or its proceeds, or for an account of such property or proceeds. Q. 18. State the provisions of the Limitation Act relating to suits of foreign contracts. How far is the foreign rule of limitation applicable to suits in India? Ans. Section 11 of Indian Limitation Act says, 1. Suits instituted in the territories to which this Act extends on contracts entered into the state of Jammu and Kashmir or in a foreign country shall be subject to the rules of limitation contained in this Act. 2. No rule of limitation in force in the state of Jammu and Kashmir or in a foreign country shall be defense to a suit instituted in the said territories on a contract entered into in that state or in a foreign country unless a. The rule has extinguished the contract, and b. The parties were domiciled in that state in the foreign country during the period prescribed by such rule. The rules which apply to the case of contract made in one country and put in suit in court of another country are the following. A. The interpretation of the contract is governed by the law of the country where the contract was made. B. The mode and the time limit within which the action relating to any contract must be brought and is governed by law of country where the action is brought. Thus, the mere fact that a suit on foreign contracts is not barred under the foreign law will not enable the plaintiff to bring the suit on the claim barred in this country. Because the person suing in this country should in matters of procedure take the law as he finds it there. Even where a suit has been dismissed, not extinguished, in a foreign country on the ground of limitation, a fresh suit can be brought in this country within the period prescribed by Indian Limitation Act. In Ganga Prasad vs. Ganesh Lal, Hair 1924 All. 161. It was observed that where the plaintiff obtains a judgment in a foreign court on a claim which though not barred under the foreign law would be barred under the Limitation Act and brings a suit on the judgment in an Indian court, it would be no defense to rely on the plea of the limitation as the foreign judgment is valid according to the therefor and is conclusive. It could be impugned only on any of the grounds enumerated in Section 13 of the Code of Civil Procedure. The result would be the same even if the contract had been made originally in India. Q. 19. What are the days which could be excluded while computing the period of limitation? Ans. Section 3 of Indian Limitation Act gives the general rule of limitation by providing, subject to the provisions contained in sections 4 to 24, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed although limitation has not been set up as a defense. So the rule that suit, appeal or application filed after the period of limitation shall be dismissed is subject to provisions contained in sections 4 to 24 of the Act. Sections 12 to 15 of Limitation Act provide for excluding certain periods while computing the period of limitation prescribed. Section 12 of Act says that in computing the period of limitation of any suit, appeal or application, a. The day from which period is to be reckoned. b. The day on which judgment complained of was pronounced. c. Time requisite for obtaining a copy of decree, sentence or order appealed from or sought to be revised or reviewed. d. Time requisite for obtaining the copy of judgment on which decree or order is founded. a. Time requisite for obtaining a copy of award shall be excluded. In Parthasarthi vs. State of AP Air 1966 South Carolina 38, it was observed that in computing or calculating the period of limitation from a particular point, Section 12 enables the exclusion of a time from that period caused by an event that intervened between the commencement and termination of said period. Section 13 of the Act lays down that the time during which the applicant has applied for leave to sue as "pauper" shall be excluded. According to this section, application must have been made for permission to sue as pauper in a suit and same is rejected. Such time which the applicant has spent in good faith for obtaining permission shall be excluded in computing prescribed period upon payment of court fees. Section 14 of the Act then provides, in computing the period of limitation prescribed for suit or application, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, should be excluded. The proceeding in such a case should have been founded upon the same cause of action and is prosecuted in good faith in court which, from defect of jurisdiction or other cause of like nature, is unable to entertain it. In Madhav Rao Narayan Rao Patwardhan vs. R. K. Govind Bhanu Air 1958 South Carolina 767, it was observed that, the essential requisites for application of Section 14 of the Act are that the party seeking pay benefit of Section 14 had to affirmatively show, I, that he had been prosecuting the previous suit with due diligence, e. that the matter in issue in the previous suit and new suit are the same, e. that the previous suit was prosecuted in good faith, iv. that the court was unable to entertain that suit on account of defect of jurisdiction or other cause of a like nature. Then Section 15 of the Act provides, 1. In computing the period of limitation for any suit or application for the execution of a decree, the institution or execution of which has been stayed by injunction or order, the time of the continuance of the injunction or order, the day on which it was issued or made, and the day on which it was withdrawn is to be excluded. 2. In computing the period of limitation for any suit of which notice has been given or for which the previous consent or sanction of the government or any other authority is required in accordance with the requirements of any law for the time being in force, the period of such notice or as the case may be, the time required for obtaining such consent or sanction is to be excluded. 3. In computing the period of limitation for any suit or application for execution of a decree by any receiver or interim receiver, appointed in proceedings for the adjudication of a person as or an insolvent or by any liquidator or provisional liquidator appointed in proceedings for the winding up of a company. The period beginning with the date of institution of such proceedings and ending with the date of institution of such proceedings and ending with the expiry of 3 months from the date of appointment of such receiver or liquidator, as the case may be, is to be excluded. 4. In computing the period of limitation for a suit for possession by a purchaser at a sale in execution of a decree, the time during which a proceeding to set aside the sale has been prosecuted is to be excluded. 5. In computing the period of limitation for any suit, the time during which the defendant has absented from India and from the territories outside India under the administration of the central government is to be excluded. Section 15. Q. 20(a) gives a promissory note to B on 1.1.83. (a) was out of India from the 1st of January 1984 to the 1st of January 1986. B. Sued A. on the 2nd of January 1986. Is the suit within the period of limitation? Decide. Ans. Subsection 5 of Section 15 of Indian Limitation Act 1963 provides, in computing the period of limitation for any suit, the time during which the defendant has been absent from India and from territories outside India under the administration of the central government, shall be excluded. In Air 1961 Mad. 199 it was observed that, when it has to be ascertained whether a suit is in time or not, the interval between the date when the cause of action arose and the date when the suit was instituted should be first computed. From that interval, the time during which the defendant has been absent from India should be subtracted by virtue of subsection 5 of Section 15 of Act. If resultant period does not exceed the time specified in column 3 of Schedule to the Act, the suit would be in time. In the case in hand, defendant was out of India from the 1st of January 1984 to the 1st of January 1986. This period will be excluded while computing the period of limitation for filing present suit. Therefore, suit is within the period of limitation. Q. 21. Examine the effect of death, fraud, or mistake on the period of limitation. Ans. Section 16 of Indian Limitation Act provides regarding the effect of death in computing the limitation period. Section 16 says, 1. Where a person who would, if he were living, have right to institute a suit or right to make application, dies before such right accrues, or where right to institute suit or make application assures only on the death of a person. The period of limitation shall be computed from the time when there is a legal representative of deceased capable of instituting such suit or making such application. 2. Where a person against whom, if he were living, a right to institute suit or make application would have accrued, dies before such right accrues, or where right to institute a suit or make application against any person accrues only on death of such person. The period of limitation shall be computed from the time when there is legal representative of deceased against whom plaintiff may institute such suit or make such application. Section 17 of Indian Limitation Act deals with the effect of fraud or mistake on period of limitation prescribed by the Act. According to Section 17, the limitation shall be computed from the time when the fraud became known to the person defrauded. Therefore, if any person by the exercise of fraud has kept away other persons from the knowledge that he has a right to file a suit, limitation will be computed from the time when such fraud became known to the person so defrauded. Where any document necessary to establish such right has been fraudulently concealed from him, or where the suit or application is for the relief from the consequence of a mistake, limitation shall be computed from the time when he first has the means of producing the document or compelling its production, and in latter case when the plaintiff or the applicant has discovered the mistake or could have discovered it. It should be from the date of the discovery of the document. The following are the essential conditions for getting the advantage of the above section. 1. The cause of action of plaintiff has been concealed from him by fraud. 1. The fraud has been done by the defendant or a person through him or who claims under him. 3. The plaint is in time since the discovery of the fraud. Exceptions. The following, however, are exceptions to the rule laid down above. Nothing in this section shall enable any suit to be instituted, application to be made to recover or enforce in charge against or set aside any transaction affecting in property, which I. In the case of fraud, it has been purchased for valuable consideration by a person who was not a party to the fraud and did not at the time of the purchase know or have reason to believe that any fraud had been committed. Or e. In the case of mistake, it has been purchased for valuable consideration subsequently to the transaction in which the mistake was made by a person who did not know, or have reason to believe, that the mistake had been made, or e. In the case of a concealed document, it has been purchased for valuable consideration by a person who was not a party to the concealment and did not at the time of purchase know or have reason to believe that document has been concealed. The main object of this section to keep the right of a person to sue suspended so long as he is not made aware of the fraud to be committed against him. Such a period is excluded from the prescribed period of limitation. It is based on the principle that a person should not be deprived from his legal right to sue simply because the period of limitation expired and he could not have knowledge of fraud done with him or likely to be done with him. According to Section 17(1), where the execution of a decree or order within the period of limitation has been prevented by fraud or force of the judgment debtor, the court may, on the application of judgment creditor made after the expiry of period of limitation, extend the period for the execution of decree or order. But such an application must be made by the judgment creditor within 1 year from the date of discovery of fraud or the cession of force as the case may be. Q. 22. What do you understand by term valid acknowledgement under Section 18 of the Limitation Act? Explain with the help of decided cases. Ans. Section 18 of Indian Limitation Act lays down 1. Where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing signed by the party against whom such property or right is claimed, or by any person through whom he derives his title or liability, a fresh period of limitation shall be computed from the time when the acknowledgement was so signed. 2. Where the writing containing the acknowledgement is undated, oral evidence may be given of the time when it was signed, but subject to the provisions of the Indian Evidence Act, 1872. Oral evidence of its contents shall not be received. Explanation. Added to Section 18 says, an acknowledgement may be sufficient though it omits to specify the exact nature of the property or right, or avers that the time for payment, delivery, performance or enjoyment has not yet come or is accompanied by a refusal to pay, deliver, perform or permit to enjoy, or is coupled with a claim to set off, or is addressed to a person other than a person entitled, to the property or right. So where prescribed period for suit or application in respect of some property or right has begun to run but has not expired, an acknowledgement in writing of such right has been made. A fresh period of limitation should be computed from the time when the acknowledgement was so signed. In Hindustan Apparel Industries vs. Fair Deal Corp. New Delhi Air 2000 Guj 261, it was held that the payment of check which is dishonored would amount to acknowledgement of debt and liability, and by necessary consequence there will be saving of limitation as envisaged by Section 18 of Limitation Act. A check would prima facie amount to an admission of debt unless contrary intention has been expressed by the person issuing the check. The principle on which Section 18 is based is that the bar of limitation should not be allowed to operate in cases in which the existence of a claim is acknowledged by persons who are under pay liability. In Tilak Ram vs. Nattu Air 1967 South Carolina 935, it was pointed out that the section requires I. an admission or acknowledgement, e. such acknowledgement must be of a liability in respect of property or right. e. it must be made before the expiry of period of limitation, iv. it should be in writing and signed by the party against whom such property or right is claimed. Q. 23A borrowed a sum of money from B. The last date for filing the suit fell on Sunday. On Monday, the next day, A gives a written acknowledgement to B. Advise B whether he should file the suit immediately or he can do so after some time. Give reasons. Ans. Section 18(1) of Indian Limitation Act provides, where before the expiration of the prescribed period for suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing signed by party against whom such property or right is claimed or by any person through whom he derives his title or liability. A fresh period of limitation shall be computed from the time when the acknowledgement was so signed. Bare reading of subsection 1 of Section 18 of the Act makes two things clear for the case in hand. Firstly, that acknowledgement must be made before the expiration of the period of limitation. That means acknowledgement must be made after the period of limitation has begun to run and while it is actually running and before prescribed period for filing suit has expired. Secondly, period of limitation and prescribed period do not express one meaning. Period of limitation according to Section 2(j) of the Act means the period of limitation prescribed for any suit, appeal or application by schedule of the Act, and prescribed period means period of limitation computed in accordance with the provisions of this Act. Prescribed period is that period which ultimately comes out to be after applying all relevant provisions of Limitation Act. Section 18 requires acknowledgement must be made before the expiration of such prescribed period. Coming now to Section 4 of the Act, which lays down where the prescribed period for any suit, appeal or application expires on a day when the court is closed, the suit, appeal or application may be instituted, preferred or made on the day when the court reopens. Section 4 of the Act contains enabling provision and simply provides that suit, appeal or application may be instituted, preferred or made as the case may be. On the reopening day of the court, notwithstanding that prescribed period had expired on a day when the court was closed. Section 4 of the Act does not in any way extend the period of limitation. In Makbur Ahmed vs. Onkar Pratap Narain Singh, Air 1935 PC 85, while considering the true scope and effect of this section, the Privy Council made the following observations. What the section provides is that, where the period prescribed expires on a day when the court is closed, notwithstanding that fact, the application may be made on the day when the court reopens. So there is nothing in the section which alters the length of the prescribed period. It follows that the acknowledgement made on the reopening day of the court cannot be said to be made before the expiration of the prescribed period, and cannot give a fresh period of limitation under Section 18 of the Act. In view of the above discussion, B should file the suit immediately on Monday itself, otherwise it would become time-barred. Q. 24. What is the effect of payment made before the expiry of the limitation? Ans. Section 19 of Indian Limitation Act lays down that, where payment on account of a debt or of interest on a legacy is made before the expiration of the prescribed period by the person liable to pay the debt or legacy or by his agent duly authorized in this behalf, a fresh period of limitation shall be computed from the time when the payment was made, provided that, save in the case of payment of interest made before the first day of January, 1928, an acknowledgement of the payment appears in the handwriting of, or in a writing signed by, the person making the payment. Section 19. For the purpose of this section. Explanation. I. Where mortgaged land is in the possession of the mortgagee, in receipt of the rent or produce of such land shall be deemed to be a payment. 2. Debt. Dues not include money payable under a decree or order of a court. Section 19. Underlying principle of Section 19 of the Act is that such payment implies an admission of a right and an acknowledgement of the corresponding liability. It would be clear from the language of the section that to attract its operations two conditions are essential. First, the payment must be made within the prescribed period of limitation, and secondly, it must be acknowledged by some form of writing, either in the handwriting of the payer himself or signed by him. In Sant Lal Mohato vs. Kamla Prasad, Air 1951 South Carolina 477, it was observed, it is the payment which really extends the period of limitation under this section. But the payment has got to be proved in a particular way, and for reasons of policy the legislature insists on a written or signed acknowledgement is the only proof of payment and excludes oral testimony. Unless, therefore, there is acknowledgement in the required form, the payment by itself is of no avail. Q. 25A owes a sum of 200 rupees, to B on a pro note. Before the expiry of period of limitation A, pays the sum of 200 rupees, to B towards that pro note. What is the effect of this payment on limitation? Ans. Section 19 of Limitation Act provides that, where payment on account of a debt or of interest on a legacy is made before the expiration of prescribed period by the person liable to pay the debt or legacy or by his agent duly authorized in this behalf. A fresh period of limitation shall be computed from the time when the payment was made, provided that save in the case of payment of interest made before the first day of January 1928, an acknowledgement of the payment appears in the handwriting of or in a writing signed by the person making the payment. In the case in hand, B has paid 200 rupees towards the pronote before the expiry of limitation. But another essential condition to invoke Section 19 of the Act is missing, i.e. the payment of 200 rupees by B does not appear in the handwriting of B or in a writing signed by B. Therefore this payment will not avail A of fresh period of limitation as provided by Section 19 of the Act. Q. 26. The defendant had taken a loan in sum of 5,000 rupees from the plaintiff on the 3rd of May 1977. The plaintiff sent a notice of demand to defendant who received it on the 27th of April 1980. Vide reply dated the 6th of May 1980. The defendant admitted the liability but requested the plaintiff to give him time till the 30th of June 1980. After waiting till the 3rd of July 1980, the plaintiff filed the suit for recovery of the amount on the 4th of July 1980. The defendant contested the suit only on the ground that he had repaid the amount to plaintiff but had not insisted for the receipt at the time of paying the amount on the 29th of June 1980. Trial court however dismissed the suit holding that the same is barred by time. The plaintiff has come in appeal and has contended that the suit is within time and further that the plea of limitation was not taken by defendant at any time. How will you decide? Ans. Section 18 of Limitation Act provides that where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing signed by the party against whom such property or right is claimed, a fresh period of limitation shall be computed from the time when the acknowledgement was so signed. Thus, one of the essential conditions for the applicability of Section 18 is that the acknowledgement must be made before the expiration of the prescribed period for a suit. Acknowledgement, as prescribed by this section, merely renews debt. It does not create a new right of action. The statement, on which a plea of acknowledgement is based, must relate to a present subsisting liability, though the exact nature or the specific character of the said liability may not be indicated in words. In the case in hand, the limitation for filing the suit was 3 years, and the same expired before the defendant admitted his liability in the reply to the notice of the plaintiff. In other words, the acknowledgement of the liability was made after the expiry of the period of limitation. Therefore, the plaintiff cannot take the benefit of the provisions of Section 18 of the Limitation Act. Moreover, plaintiff cannot take any advantage of the fact that defendant had not raised at any time defense of suit being barred by limitation because in view of Section 3 of Indian Limitation Act, It is the duty of court to see whether suit is within the prescribed, and court may dismiss a suit if filed after the prescribed period, although limitation has not been set up as a defense. Q. 27. What is the law of limitation as to acknowledgement made by one of several persons or against the others who are also interested in the same property? Ans. It has been provided in Section 20 of the Limitation Act that a lawful guardian or manager or an agent duly authorized can acknowledge the liability or make payment on behalf of persons under disability. Section 20. 1. The acknowledgement of payment by one of the several joint contractors, partners, executors or mortgagor shall not by itself be taken as an acknowledgement or payment by the other so as to bind some other person, but that there must be some express or implied authority to bind the others by the acknowledgement of any one of them. The reason behind this rule is that since an acknowledgement and repayment are two acts which made the period of limitation run afresh, it would be an injustice if the debtor is debarred from the right pleading the statute of limitation due to the co-debtor or an act of an agent unless due authority among co-debtors is established, in which case alone an acknowledgement by one of several joint debtors will bind him alone and not the others. There are, however, following exceptions to the above provisions. 1. An acknowledgement signed by or by the agent of a Hindu widow or other limited owner under the Hindu law shall be binding on the reversioner. 2. An acknowledgement signed by or by the agent of the manager or the carter of joint Hindu family shall be binding upon the whole family provided the acknowledgement is in respect of a liability incurred by or on behalf of the whole family. Q. 28. Does the substitution or addition of a new plaintiff or defendant affect the period of limitation? Ans. Effect of substituting or adding new plaintiff or defendant. It has been laid down in Section 21 of this Act that, where after the institution of a suit a new plaintiff or defendant is substituted or added, the suit shall as regards him deemed to have been instituted when he was so made a party, provided that the court is satisfied that omission to include a new plaintiff or defendant was due to a mistake made in good faith. It may direct that the suit as regards such plaintiff or defendant shall be deemed to have been instituted on any earlier date. Section 21, 1, says, nothing in subsection 1 shall apply to a case where a party is added or substituted owing to an assignment or devolution of any interest during the pendency of a suit, or where the plaintiff is made a defendant or defendant is made a plaintiff. The provisions contained in Section 21, 1, of this Act apply to the cases in which the new plaintiff is added or substituted in his own right. It will help the plaintiff considering himself as an independent party instituting a suit in the form of an original plaintiff. The cases in which the addition of a plaintiff is done during the course of the suit in consequences of assignment of interest from the original plaintiff. The provision of subsection 1 of this section shall not apply. In Mukesh Kumar and others vs. Call, Harbans and others, Air 2000 South Carolina 172, Supreme Court observed, Section 21 of Limitation Act provides that wherever on institution of suit, a new plaintiff or defendant is substituted or added, the suit shall as regard him be deemed to have been instituted when he is so made a party. However, if court is satisfied that omission to include a new plaintiff or defendant was due to mistake made in good faith, it may direct that suit as regards such plaintiff or defendant shall be deemed to have been instituted on earlier date. Subsection 1 therefore makes it very clear that these provisions would not apply to case where a party is added or substituted owing to assignment or devolution of any interest during the pendency of suit, or where plaintiff is made defendant or defendant is made plaintiff. Q. 29 describe the provisions relating to continuing breaches of the contract and continuing tort under Limitation Act 1963. Uns. Continuing breaches and torts. The provisions contained in Section 22 of this Act aim to prevent the multiplicity of suits and to enable a person or party to bring a cause of action for all losses suffered by him during the whole period when such breach continues. According to Section 22 of this Act, in case of a continuing breach of contract, or in the case of a continuing tort, a fresh period of limitation begins to run at every moment of the time during the breach of the contract or the tort. As the case may be, continues. Section 22. Continuing tort. A wrongful act complained of creates a continuing source of injury in case of a continuing tort. For instance, a continued trespass upon immovable property of others, or continued presence of objectionable features at a religious place open for public, or contended obstructions to a drainage channel or to a water course. The continuing tort renders a person liable for its continuing acts, and every such moment is continuous source for which a fresh action can be maintained. Some of the examples of continuing wrongs are: a. Causing disturbance to a right of ferry. b. Interference with the right of irrigation. c. Trespass. d. Any disturbance in drawing water. a. An infringement of a trademark or copyright. f. Refusal of wife to maintain conjugal rights by not returning back to her husband's house, etc. Continuing breach. A distinction can be made between "continuing breach" from "excessive breaches." The examples of continuing breaches are failure to pay rent, interest or other sums payable periodically. The cause of action for each of such breach arise from the date of such breaches. The successive breaches can also cause an independent cause of action, but it should be within the period of limitation. A suit for the recovery of interest or rent, as such, cannot be instituted after the expiry of the period of 3 years from the date when it became due. Q. 30 state the rule of limitation in case of suits for compensation for acts which do not give rise to a cause of action unless some specific injury actually results therefrom. Uns. In ordinary cases, time usually runs from the commission of the wrong and not from accrual of damage. But where cause of action lies, not in specific act or omission, but in the resulting damage, time runs when plaintiff sustains loss. According to Section 23 of the Limitation Act, in a case of a suit for the compensation for an act which does not give rise to cause of action unless some specific injury actually results therefrom, The period of limitation shall be computed from the time when the injury results. Thus, in order to attract the provisions of this section, the following conditions must exist. I. It must be a suit for compensation. E. The cause of action should lie, not in any specific act or omission but in the resulting damage. Where the act of the defendant itself constitutes a legal injury, this section has no application, and the mere fact that the plaintiff suffers damage subsequently will not enable him to compute the period of limitation for compensation in respect of such act from the date of the damage. This section does not extend or restrict any period of limitation but alters the date or time from which limitation has to be computed. Q. 31A owns the surface of a field. B owns the subsoil. On the 1st of January 83 B, digs coal thereout causing immediate apparent injury to the surface, but at last on the 1st of January 84 the surface subsides. From which date does the period of limitation in case of suit by A against B run? Discuss. Ans. Section 23 of Indian Limitation Act 1963 lays down. In the case of a suit for compensation for an act which does not give rise to a cause of action unless some specific injury actually results therefrom, the period of limitation shall be computed from the time when the injury results. So the principle of Section 23 of the Act is where the cause of action lies not in a specific act or omission but in the resulting damages. The period of limitation runs from the time when plaintiff sustained the loss. In the case in hand, act of B, digging up the coal from the field by itself did not create the cause of action for A, but as result of B's such act, the surface subsides on the 1st of January 84. Cause of action arose and therefore time of limitation shall run from the date of subsidence of surface. Q. 32. What is the calendar to be used in computation of period of limitation under Indian Limitation Act? Ans. According to Section 24 of the Limitation Act, all the instruments shall for the purposes of this Act be deemed to be made with reference to the Gregorian calendar. Section 24 provides that for the purpose of the Limitation Act the Gregorian calendar is to be used. Gregorian calendar means the British calendar introduced by Pope Gregor XIII in 1582. In India there are in use several calendars as, for example, Samvat, Bengali, etc. But the period of limitation must not be calculated according to the native date. Where an instrument bears a native date only, and is made payable after a certain time, that time whether denoted by the month or the year, is to be computed according to the British calendar. Q. 33. How is a right of easement acquired under the Limitation Act? Ans. Section 25 of the Limitation Act says 1. Where the access and use of light or air to and for any building have been peaceably enjoyed therewith as an easement, and as of right, without interruption, and for 20 years. And where any way or watercourse or the use of any water or any other easement, whether affirmative or negative, has been peaceably and openly enjoyed by any person claiming title thereto as an easement and as of right without interruption and for 20 years. The right to such access and use of light or air, way, watercourse, use of water, or other easement shall be absolute and indefeasible. 2. Each of the said periods of 20 years shall be taken to be a period ending within 2 years next before the institution of the suit wherein the claim to which such period relates is contested. 3. Where the property over which a right is claimed under subsection 1 belongs to the government, that subsection shall be read as if for the words 20 years, the words 30 years were substituted. Explanation. Nothing is an interruption within the meaning of this section, unless where there is an actual discontinuance of the possession of enjoyment by reason of an obstruction by the act of some person other than the claimant, and unless such obstruction is submitted to or acquiesced in for 1 year after the claimant has notice thereof and of the person making or authorizing the same to be made. Section 25 provides as to the acquisition of easements by prescription. Where the access and use of light or air to and for any building have been peaceably enjoyed therewith as an easement, and as of right without interruption, and for 20 years. The right to such access and use of light or air shall be absolute and indefeasible. Subsection 2 of Section 25 lays down the period of 20 years required for creating a right of easement shall be taken to be a period ending within 2 years next before the institution of the suit wherein the claim to which such period relates is contested. The maxim of law that the enjoyment of an easement must be NICV, NEC calm, NEC precario, indicates that the enjoyment of easement pleaded to be the basis for acquisition of ownership must be without violence or force, without stealth. It must not also be permissive or by leave or license. There are following prerequisites of the Section 25. 1. Peaceably. The enjoyment of an easement must not be by violence or force. 2. Openly except in case of light and air. The enjoyment must have from the very beginning been visible and manifest, not secret or clandestine. 3. As an easement. The claimant must have enjoyed the right as an easement. If there had been any unity of possession and ownership, he could not have enjoyed an easement. Where a person claims a site as owner, he cannot claim a right of way of user or watercourse over the same as an easement. 4. As of right, NEC precario. In order that an enjoyment should be as a right, the person claiming it must have exercised it without leave or license from anyone. 5. Without interruption. The enjoyment for the period of 20 years must be without interruption, i.e., without any obstruction of prevention of the use of the easement by some person acting adversely to him. According to the explanation to this section itself, nothing is to be considered as interruption unless a. There is an actual discontinuance of the possession or enjoyment. b. Such discontinuance is by reason of the act of some person other than the claimant himself, and c. Such obstruction is submitted to or acquiesced in for 1 year after the claimant has notice thereof and of the person making. 6. For 20 years. The enjoyment must be for 20 years. If the property belongs to the government, must be for 30 years. The enjoyment must be continued down to within 2 years of the date of suit in which the right is contested. That is to say, where a person is in the continuous enjoyment of an easement for more than 20 years and no obstruction is thereafter made. He must bring his suit to establish his right within period of limitation of 2 years from the date of obstruction. Section 25 of Act has to be read with Section 26, which lays down where any land or water upon, over or from, which may easement has been enjoyed or derived has been held under or by virtue of any interest for life or in terms of years exceeding 3 years from the granting thereof. The time of the enjoyment of such easement during the continuance of such interest or term shall be excluded in the computation of the period of 20 years in case the claim is within 3 years next after the determination of such interest or term, resisted by the person entitled on such determination to the said land or water. Q. 34 When does a right of easement become absolute and indefeasible? Ans. It has been laid down in Section 25 of the Limitation Act that the right of easement through prescription can be acquired as follows. 1. When the access and use of light or air to and for any building have been peaceably enjoyed therewith as an easement and as of right without interruption for 20 years. And where any way or watercourse or the use of any water or any other easement has been peaceably and openly enjoyed by any person claiming title thereto as an easement and as of right without interruption for 20 years. The right to such access and use of light or air, way or watercourse, use of water or other easement shall be absolute and indefeasible. Section 25, 1, provides that each of the said periods of 20 years shall be taken to be a period ending within 2 years next before the institution of the suit wherein the claim to which such period relates is contested. Further by subsection 3, the period of 20 years is extended to 30 years if the property over which the right is claimed belongs to the government. The following condition must be satisfied for the acquisition of right to easement. I. Peaceably. In order to establish a right of easement, it is enough for the plaintiff to prove that he has been exercising the right peaceably and without any interruption, without express or implied permission of the owner of the servient tenement and without secrecy or stealth. The word, peaceably, means that the dominant owner has neither been obliged to resort to physical force himself at any time during the period of enjoyment, nor had he been prevented by the use of physical force by the defendant in his enjoyment of such right. Openly, except in the case of light or air, the enjoyment must be open and manifest and not clandestine. The reason of the requirement that the user must be open lies in the fact that acquiescence lies at the root of all prescription. And where the enjoyment is not open, it cannot be said that the owner of the servient tenement actually or constructively acquiesced in or consented to the easement. Without interruption. An interruption, within the meaning of the Act, is an actual discontinuance or cessation of enjoyment of user by reason of an obstruction submitted to or acquiesced in for a year, not by the mere voluntary act of the claimant of the right but in consequence of an obstructive act done by a person other than the claimant. But if a cessation of user takes place due to an accident or a voluntary act or omission of the claimant himself, then it does not amount to an interruption. IV. As an easement, the claimant must have enjoyed the right as an easement. Where there is unity of possession or ownership in the same person of both the tenements, there cannot be any enjoyment as an easement during the period of unity. Q. 35 discuss the provisions of Indian Limitation Act 1963 regarding the acquisition of ownership by possession. Ans. The general rule of law of limitation is that it only bars the remedy and does not extinguish the right itself. In other words, law of limitation lays down the rule that when a suit or appeal or application is filed after the prescribed period of limitation, then such suit or appeal or application shall be dismissed. Such dismissal means the court will not grant remedy if asked for after the prescribed of limitation, but law does not dispute the right of litigant. Section 27 of Act is the exception to this general principle so far as suits for possession of property are concerned, and lays down that after the expiry of period thus prescribed for instituting a suit for possession of any property, the person who should have instituted such suit but has failed to do so, shall cease to have any right to the property. After the expiry of its period, the law declares simply that not only the remedy is barred but that title is extinct in favor of the possessor. In Banarsi Das vs. Jivan Ram, Air 1995 P&H 85, it was observed, a bare perusal of Section 27 of Indian Limitation Act would show that after expiry of the period of limitation prescribed for filing suit for possession under the Limitation Act, even the right to sue for possession is extinguished. Article 64 of Schedule of Limitation Act says that period of limitation for suit for possession of a movable property based on previous possession and not on title, when the plaintiff while in possession of the property has been dispossessed, is 12 years, and such period begins to run from the date of such dispossession of plaintiff. Article 65 says that period of limitation for filing suit for possession of a movable property or any interest therein based on title is 12 years, and period of limitation begins to run when the possession of defendant becomes adverse to the plaintiff. So in all suits for possession based on dispossession, whether plaintiff had title or not, the burden of proof is on the plaintiff to prove that he was in possession and was dispossessed within 12 years of filing suit, and in suit for possession based on title, burden of proof is on defendant to prove that his possession over suit property becomes adverse to plaintiff for beyond 12 years of the suit. Upon the proof of defendant being in adverse possession for property for period of beyond 12 years, a period which Article 65 prescribes within which plaintiff can file suit for possession on the basis of title, plaintiff's right to property will extinguish to possessor. The concept of adverse possession contemplates a hostile possession, i.e. a possession which is expressly or impliedly in denial of the title of the true owner. Possession to be adverse must be a possession by a person who does not acknowledge the other's right but deny them. The full period prescribed for a suit for possession must have expired. Otherwise the title of the true owner is not extinguished in favor of wrongdoer. An owner does not lose his right to it merely because it happens not to be in possession of it for 12 years, but his right is extinguished only when somebody else is in adverse possession of property of lawful owner and no suit for possession has been filed within prescribed period of limitation. Institution of the suit for possession is sufficient to bar the operation of Section 27 of Limitation Act. Q. 36. Whether the Limitation Act 1963 applies to proceeding under Articles 32 and 226 of the Constitution. Ans. The Limitation Act is an exhaustive code governing the law of limitation in India in respect of all matters specifically dealt with by it. And the courts are not permitted to travel beyond its provisions to add or supplement them. In respect of matters not dealt with by it, the Act does not apply and there will be no limitation in respect of such matters. No limitation is prescribed for filing a writ petition under Article 32 or 226 of the Constitution of India, and therefore Act does not apply to such proceedings. SMT. Rajmata Vijay Raje Scindia vs. State of UP, Air 1986 South Carolina 756. Q. 37. What provisions have been laid down in the Limitation Act regarding the application of local or special laws? Ans. Such a provision has been made under Section 29, which runs as follows. 1. Nothing in this Act shall affect Section 25 of the Indian Contract Act, 1872. 2. Whether any special or local law prescribes for suit, appeal or application a period of limitation different from the period prescribed therefor by a schedule. The provisions of Section 3 shall apply, as if such period were prescribed therefor in that schedule, and for the purpose of determining any period of limitation prescribed for any suit, appeal or application by any special or local law. The provisions contained in Sections 4 to 24 shall apply only insofar as, and to the extent to which they are not expressly excluded by special or local law. B. The remaining provisions of this Act shall not apply. 3. Nothing in this Act shall apply to suits under the Indian Divorce Act. 4. Sections 26 and 27 and the definition of backward easements in Section 2 shall not apply to cases arising in territories to which the Indian Easements Act, 1802, may for the time being extend. Section 29. All that Section 29, 2, lays down is that where a special or local law prescribes a period of limitation, the excluded portion of the Limitation Act shall not apply. It was held in Azizul Haq vs. the State, Air 1980 All 149. That Section 29, 2, of the Limitation Act lays down that Sections 4 and 24 of the same Act would apply even in the case of a special or local law unless their application is expressly excluded by such special or local law. Q. 38. What provisions have been made in Limitation Act 1963 for suits etc., for which the prescribed period is shorter than the period prescribed by Limitation Act 1908. Ans. Section 30 of Indian Limitation Act says, notwithstanding anything contained in this Act, any suit for which the period of limitation is shorter than the period of limitation prescribed by the Indian Limitation Act, 1908, may be instituted within a period of 5 years next after the commencement of this Act or within the period prescribed for such suit by the Indian Limitation Act, 1908. Whichever period expires earlier. B. Any appeal or application for which the period of limitation is shorter than the period of limitation prescribed by the Indian Limitation Act, 1908, may be preferred or made within a period of 90 days next after the commencement of this Act or within the period prescribed for such appeal or application by the Indian Limitation Act, 1908. Whichever period expires earlier. In Trivikram vs. Vittal Rao, Air 1980 Bombay 1, it has been held that the effect of the provisions in Clause B of Section 30 is to make a specific provision in a case where the limitation prescribed for an appeal or an application under the 1963 Act is shorter than the limitation prescribed by the 1908 Act. Where the limitation for an appeal or an application under the 1963 Act is shorter than the period of limitation prescribed by the 1908 Act. Clause B requires that such appeal or application must be made within a period of 90 days after 1 April, 1964 or within the period prescribed by the 1908 Act, whichever period expires earlier. As the proviso contained in column 8 of Article 183 of 1908 Act is omitted in Article 186 of the 1963 Act. The period of limitation for making an application for execution under the 1963 Act is shorter and therefore, the provision of Section 30(b) of the 1963 Act will apply in such case.